Hey, good morning. Today is Friday, January 26, 2024. It's 9 a.m. This is meeting Senate Natural Resources and Energy. We're doing some bill walkthroughs this morning and have Village Council with us. And on some later bills, we're also going to have the senator who's sponsoring. And then we'll finish up with brief discussion of some mini bills and the process for getting them up on our wall next week. So, Mr. O'Grady, if you could join us and help us by walking through S 273 and activating the collection and recycling of waste motor vehicle tires. And many members should, since we did the walkthrough with you, those should have them. If you are using hard copies, you should have them already.
So this is Mike O'Grady, Legislative Council. The bill you have in front of you is an extended producer responsibility program for waste tires. It is very similar to many of the other extended producer responsibility programs you have seen this year and in prior years. To start the walkthrough of the bill, I think I want to kind of take you a few pages forward in the definitions and then walk back from there. So this is a program for waste motor vehicle tires. So beginning on page 5, what is a tire? A tire is a continuous solid or pneumatic rubber covering encircling the wheel of a motor vehicle. What is a motor vehicle? Well, a motor vehicle tire, page 4, is a tire designed for on-road use on a motor vehicle. Motor vehicle is on page 4, getting at line 1, and this is fairly consistent with how you define motor vehicle in the transportation laws, but you have to make some distinctions in the exception. So a motor vehicle is all vehicles operated in the state that are propelled or drawn by power other than muscular power. That includes ATVs, motorcycles, farm tractors and farm trailers, motor driven cycles, but it does not mean electric personal mobility devices, electric bicycles, motor assisted bicycles, adaptive electric cycles, lawn mowers, or specialized construction vehicles. So,
Can I ask you, as a in the past, what is an adaptive electric cycle?
We're talking about recycling tires.
Yeah.
And
Kind of tires.
we have this is a prescribed method on how to do it.
No, we're at the point of what are we really talking about?
Yes.
So how, we've already been given a roadmap and a direction.
But we're working on definitions, then we're gonna go back to the beginning, so we'll know what we're talking about, and then we'll go forward.
So what's the problem we're trying to solve?
That,
Well, not now. No, we're reading the text of the bill. And we're in the definitions.
I can tell you the problem. So the problem is that the disposal of tires is expensive for solid waste management districts. And consequently, they charge for the disposal of tires, which gives persons who potentially can't afford it or don't want to pay it an incentive to illegally dispose of those tires. And there are examples around the state of illegal tire dumps. There are efforts made annually to pull tires out of the river. Tires that are not properly stored are a water quality, air quality, public safety threat because they can catch on fire and it's very difficult to put out tire fires.
yes,
So we're trying to solve that problem.
Trying to move the cost of the tire collection and disposal off of the consumer and the solid waste management districts to the manufacturer.
And presumably there are several different ways this could be tackled.
Yes, I mean, there's definitely different models for tire. Disposal programs across the country. The EPR is one of them, where you just shift the requirement for collection and management to the manufacturer. Other states have mandated fees on every tire sold. And those fees are paid to government to manage tire disposal and management programs. And then others just have prohibitions from the landfill. And that basically shifts the requirement to the retailer of tires. But it also leads to the issues that I've already identified, because people just. Because the retailer then charges a $10 tire fee, right? And then the customer says, oh, no, I'm gonna keep them because I'm gonna put them on my other car.
I mean, put them on my neighbor's yard.
Right. And
And some people just go to New Hampshire to get their tires.
well, that is the discussion that has arisen in the past. When the legislature has tried to do the model of putting a fee on a tire that's paid to the state for the purpose of collection and management. The tire dealers on the borders are very opposed to such a model, because it makes them, in their testimony, non-competitive with New Hampshire.
So. We have. Some models out there such as the Mercury. Switch for. And we have the bottle build model. And maybe there are a couple of models they haven't thought of in the last 30 seconds. And this bill has. Made a selection on which model to use, the one that you're.
Yeah, this is a model that doesn't have that obvious overt fee on each tire, right? So the cost needs to be assumed by the manufacturer or stewardship organization. Obviously, the cost is going to get passed back, likely through the cost of the tire. But many tire retailers are regional branches. All tire manufacturers are national or international. Not complete is it's an international brand, and so they will be able to theoretically disperse the costs across all of their tire sold region across the US.
So this. Well, this question is, this bill. Tackles a problem that we know exists and has selected a solution. To the problem that I would say is similar to the way we deal with Mercury switches or whatever.
Mercury switches.
As we look at this bill, that decision has, when we pursue this bill, that decision has been made by Senator White, who's been working on this for a while and believes that this is the best approach.
Well, it's like any bill, it's the
Well,
sponsored
yeah.
proposal.
But I'm. Thank you, Chair, but I'm also, this is a very important topic for how we dispose of tires generally, so if folks have other concepts or ways to handle it, like I'm not, this isn't the Bible of, it's not a sacred text of what we should be doing, we can change things. I did just wanna ask, council, there was a good question that was asked when I was doing my walkthrough, which was essentially what happens to a tire that you go to Tire Warehouse. And they store your tires, but you say you keep the summer tires because I'm buying new summer tires. What is required of those places now? Do they have the same requirements? And what do they do with them? If you aren't disposing of them yourselves and you basically have a company.
So if they're going to take them right now.
Yeah, And you normally pay them
And,
to do that.
and there, you're not gonna get that back at any point in the
Yeah.
future. They sell them. They sell them for fuel.
I believe the chair was talking about the Crossway Champlain, the power. They have your foundation.
Right,
It's not, it's,
tested it out.
there's, not just fuel, some of them sell them to grind. And then the grind is used in either recycling, recycled tires, or. I don't know if you've ever been to a playground and you're on the squishy stuff on the ground. Some of that squishy stuff is made from recycled tires,
Tracks,
track,
racing track.
and sometimes some states allow it to go into asphalt, for roadways, Vermont doesn't, but. It's not being sent to facilities in Vermont for shredding and recycling. But then Maine burns tires, so we send tires to Maine to burn.
They got prevailing wind.
So does Vermont doesn't, that's to know all our waste tires leave the state.
To my knowledge, yes.
Yeah, no one, there was someone in Ferrisburg who was trying to run an operation for a while, but I think he has ceased operation.
So that's the issue.
And do we still have illegal tire dumps of worrisome sizes around where people are talking about? I remember 10 years ago, we talked about the fire hazard emissions.
Yeah, I mean, there's one in Greensboro right now that the legislators from Greensboro are trying to get the agency, and have been trying to get the agency to clean up for a while. And the agency's issued, enforcement letters and administrative orders. They're gonna have to go to court, they're gonna have to get an order, which is what they had to do. Everybody remember the Milton junkyard, salvage yard? And
Those were the buses around is used as a fence.
Yeah, and that had a literal mountain of tires. And it took years to get that resolved. And so I think this program is designed to help eliminate that by putting the onus on the manufacturer, collection and management. And then part of this program is a directive that at least 50% of what they collect has to be recycled or reused as part of the program, and that it can't all just be sent somewhere for fuel.
Like I said, I asked the last question and that was wrong. So,
There McDonald's?
so there, one model is the mercury switches. Which I think that's.
The switch program is a bounty program. It's not the best model. It's not the best comparison. Your Mercury lamps is a better.
Okay. And another model would be the bottle bill where you buy the tire, you pay your fee, and when you turn the tire in, you get it back, let's say.
I don't know of any state that does a tire redemption. They just have the fee.
Well,
And you don't get it back.
so,
How about?
well, that would be a model that hasn't been explored because
So
people who explore that have never heard of it before.
that model has been explored.
Okay. And its faults are,
Its faults are that it creates substantial opposition from the retailers on the borders. Because they feel it makes them not competitive with other states.
well, it would. Because it has the same flaws that the bottle bill has.
Well, there was a tire,
I mean,
there was a waste tire working group. 10 years
Is that,
ago.
is there a plum assignment or?
I fortunately, somebody took that from me, somebody in the garden took that from me. I can give you the waste tire report. if that addresses any of these questions.
Thank you, Mr. Chair, for your patience and trying to look at the big pictures and the choices we have before us before heading down the road and passing other possibilities that have been from sailing by over enough.
I was just sort of familiar alongside things like our paint program or
Household hazardous waste,
household hazardous waste, the newest
the
edition,
newest condition.
batteries. But
Which present different challenges and similarities.
um,
So I'm going to send you what's called this tire stakeholder group report.
did you,
Equal.
I once brewed a beer at home that reminded me of the Robert. And I said it was, I named it over,
I'll send it to Jude.
and then they even had a tagline, it was the beer you don't want to tire. That was one of those beers that I gave away as much as I could.
Oh dear.
So back to the question, what is an adaptive electric cycle?
Thank you.
It's an electric bicycle or an electric cargo bicycle that has been modified to meet the physical needs and abilities of the operator or a passenger. So you see what a motor vehicle is and what a motor vehicle isn't and what a motor vehicle tire consequently there is. You'll see that this program will apply to waste tires on page 5, line 17. So that motor vehicle tire that has been removed from a motor vehicle and is no longer suitable for its original purpose because of wear, tear, damage, defect, or other reasons. The requirements for establishing this program will be on the manufacturer. I won't go through that definition. It's very similar to other definitions of manufacturer you have seen in these programs. Or it's on the Waste Tire Stewardship Organization, which is the organization appointed by multiple manufacturers that takes on the responsibilities and liabilities of those multiple manufacturers. So on page 6, line 4, you'll see the establishment of the program. The first thing, as with all these programs, is a sale prohibition beginning January 1, 2026, except for a small manufacturer exemption that I'll review later. A manufacturer of a motor vehicle tire shall not sell, offer for sale, or deliver for subsequent sale a motor vehicle tire unless all the following have been met. They're implementing an approved waste tire stewardship plan, they're participating in, or they're participating in a waste tire stewardship organization, and they have paid their fee, and they have a the name of the manufacturer's brand are on the agency's website as covered by an approved tire stewardship plan. So those are all pretty similar to other programs. Then you'll start to see the components that lead up to implementation of the plan. At first is that the manufacturer of the waste tire stewardship organization has to register with ANR on or before July 1, 2025. They have to show on the registration form, the list of the manufacturer's brands on page 7, line 14. The name and address of a person that's responsible for ensuring compliance. And if it's a waste tire stewardship organization, they have to list all the manufacturers that are part of their program and how on page 8, line 4, they comply with all the manufacturers' requirements for sale prohibition of plan or an annual report. So this, let's just stop there for a second. This is one of those programs where not all manufacturers like each other and don't want to all work together. So you might have either a manufacturer that's big enough to do its own plan, or you'll have manufacturers that don't want to work together. So there's opportunity for multiple plans here, multiple stewardship organizations, because of the nature of the industry and how some of them don't like each other.
Is this what, just trying to remember other instances, this happened for batteries and e-waste.
It started, this more closely follows batteries than probably any other program.
Okay.
And you'll see later on, one of the unique parts of the battery program is the reimbursement and cause of action sections. Because they don't like each other and they want to be able to say, this is the law for me to get reimbursement from you, and if you don't give me reimbursement, I get to sue you. They want that type of remedy, so you'll see that here, but that all comes out of. They don't play well in the same sandbox, right, and so. There's opportunity for multiple plans, because there's gonna be multiple plans, there's gonna be these. Unique aspects to the program. But not so much unique anymore, just maybe uncommon. So then you come down on page 8, line 15, 7606, the Waste Tire Stewardship Organization. What they have to do, very similar to what the registration requirement is. They have to assume the responsibilities of the manufacturers participating in the program. On page 9, line 1, they can't create unreasonable barriers for participation by other manufacturers. They need to maintain a website that lists all the manufacturer brands and manufacturers covered by the stewardship organization. Then you get to the plan.
Quick question, sorry, are there neighboring states taking this thing, a similar strategy right now?
This would be one of the first in the state,
Yeah.
first in the nation, I should say. To do this type of program. As I said earlier, many states have the fee at sale
Yeah.
model.
Yeah.
Especially the larger states. Where you don't have the border issue as much.
Yeah.
Page 9, line 8, this is what has to go into a stewardship plan. So on or before October 1, 2025, the manufacturer has to submit to A&R a proposed plan. The plan has to include specific content. Page 9, line 16, it has to list the manufacturers and the brands that are covered by the plan. Page 10, line 1, it needs to provide for free collection of waste tires. You'll see that it's basically up to 12 tires. We'll get down to that. That can be provided for free collection. It has to provide convenient collection. So first, under convenient collection, the organization needs to notify all retailers of an opportunity to participate as a collection point. And then all retailers, all solid waste management facilities, and all municipalities will have an opportunity to opt in to be a collection point. So all of your local dumps that are already collecting tires, all of your local tire service providers who do collect your waste, they all will have the opportunity to be a collection point underneath this program.
Similar to bottles.
Well, no, the bottles is a mandate. So if you sell.
We're talking mechanism, whether it's, we
Right.
haven't gotten to whether it's mandated. That's a separate issue.
This-
This is that issue. It's an opt-in. It's not a mandate. It's not a mandate for the retailer to be a collection site. That's it. I went to Jiffy Lube last week because I couldn't get into Toyota to do my Jiffy Lube now sells tires. I don't think Jiffy Lube has the space to be a waste tire collection facility. Or if they do, they're gonna have to maybe get some new infrastructure. But so they might say, no, we're not gonna opt in, or we're still gonna sell. But we're not gonna opt in to be a collection.
We've allowed auditors, that people sell bottles, not to collect the bottles.
Only if they're in a certain size retail space.
Jiffy Lube says.
5,000 square feet or less, so
Yeah,
it's,
yeah.
yeah. So, but there's no automatic exemptions in here, it's you choose to be versus not. So my assumption, this would be an economic benefit potentially to certain locations.
Well, it hopefully will shift the costs off of those retailers because they're no longer. You know, it's gonna be a cost benefit thing. How much are they making when they sell their tires for reuse or fuel? And that will involve their transportation costs or, you know, what they get back in the market. I would have to think that ultimately that this program will be a cost benefit.
When a collection point has tires, ends up with tires from 5 different manufacturers, is someone gonna have to sort those tires and say, this is a Acapulita, the Michelin, it's a Continental.
We're gonna get to that as a minute.
Hey, this is Ben's built, all right, and they're hold on.
The Artisan tires.
So they have to provide page 10, line 13, provided a minimum in each county, not fewer than 2 collection facilities. And they have to provide for the acceptance from a covered entity. Covered entity is basically a person of up to 12 waste tires per visit. And a collection facility may agree to accept more than 12 if they want to. They also have to have a proposal for how they are going to address legacy waste tires. So legacy waste tires are the tire dumps, the illegal tire dumps that are out there. So each plan shall include a proposed method of collecting tires from or eliminating those legacy waste tire piles. And proposed methods may include financial payments to property owners, penalties on collection, or other incentives. There needs to be a collection rate proposed in the plan. At first, the collection rate is going to be 50% of the participating manufacturer's tires sold in the previous calendar year. Now that can go up, and you're going to see a reason why it's going to go up in a minute. So each waste tire stewardship plan shall include a description of the method that will be used for disposition. As I referenced earlier, at least 50% that's collected needs to be recycled or reused, provided that the use of waste tires as fuel shall not be considered reuse or recycling. There has to be education materials so that the consumers are informed of their opportunity for free collection and the location of those collection points. Page 13, line 4. There has to be, they have to comply with the relevant environmental standards for collection, transport, and disposal. And then there has to be a reimbursement component in the plan. So reimbursement, if you're a manufacturer that's in the same plan or same organization, they're gonna sort your brands because that's how they're gonna allocate the costs of the program. If you get collection of a tire that's a brand that's not in your plan, you will have the opportunity that we will see in a minute to seek reimbursement from that other plan or that other manufacturer. And we'll see there's a mechanism to that. That might not be as simple as you might like, but it takes away some disincentives, and we'll talk about that in a minute.
So the way we get people, if the majority of tires in, but if you sell in Vermont, you have to participate.
To sell in Vermont, you need to have a waste tire stewardship plan as the manufacturer. The manufacturer can meet that requirement by participating in a stewardship organization. Stewardship organizations have to have a plan for all of their participating manufacturers.
And is it highly unlikely that people buying tires from other places out of state are ever gonna pick up a brand that's unique, not available in Vermont, so you have sort of a orphanage tires.
There potentially can be some orphan tires, yeah.
But not probably not so many.
Not so many. I think where the opportunity for the orphans are is on the farm tractor tires. Because you may not be buying that equipment from Vermont, it might be coming from Indiana.
We excluded farm tires as tires, right?
Now you included, or you didn't include construction equipment, lawnmowers. But you did include farm drive. That's where I think of it.
Yeah, I can imagine, it had some tires, it was interesting. Sarah White,
Thank you, Mr. Chair. There are like specialty tires for cars that have different. You know, widths, sizes, all of that, and they are, and Senator Watson had asked a question during the walkthrough, you know, are there potentially like an artisan tire? How does that work? And I did a little bit of research after Senator Watson asked that question, and what I picked up on was the manufacturers tend to be the same, but then it's like a specialty type of tire versus like an individual company that's making a special type of tire. And you're smiling, so that means that I'm in trouble.
No, you're not in trouble. I think the specialty tires come up with racing.
Yeah,
And off-roading. And so there are special off-road tires, there are special manufacturers or individual manufacturers that make good special off-road tires. If they're selling in the state, they're gonna be subject to it. You know, your treadless tire for racing at Thunder Road, Governor Scott. Tires, you know,
yeah.
that manufacturer is still going to be subject, that's still a motor vehicle, still a waste vehicle. Waste tire. And so they're still part of the program.
Thank you.
Do you want me to pause so Senator Harrison can go, or?
well, it's on a different,
I'll stay, I'm fine.
Okay.
how about if we finish this one and then jump to that and then go back?
With every one of these programs, there's an annual report from the manufacturer to the agency, letting the agency know the number of tires collected, the number, the collection rate, the locations of collection, educational materials, how they manage them and their disposition, and how many went for fuel on page 14, line 7. They also have to report the cost. And then with all EPR programs, there's an audit of the program after 5 years to look at its efficacy and its cost and compare it to other similar programs in other jurisdictions. And then make recommendations and changes. The new manufacturer requirement on page 15, you can't, if you somehow you're a new manufacturer selling into the state in the middle of the year or after January 1, 2026, you have to come up to compliance before you can start selling. And then there is a small manufacturer exemption, page 15. If you're really truly a custom tire and you're only selling less than $5,000 worth of your tire in the state each year, if you don't, you're not subject to the program. A&R has some responsibilities. They have to approve the plans, they have to register the waste stewardship organizations, and they have to assess the performance of the plan, and they have to approve any plan amendment. That's page 16. Page 17, well, we can actually move on to page 18. This is the retailer obligations. They cannot sell a tire beginning January 1, 2026 unless the manufacturer is implementing a plan or part of the stewardship organization. However, there is an inventory exception if they purchase the tire prior to January 1, 2026, they get to continue to sell it, even if the manufacturer is not implementing a plan, or if the manufacturer's plan is somehow revoked during or after the retailer purchased it after January 1, 2026, the retailer is not going to be punished by the manufacturer's non-compliance. They can continue to sell the tire. So there are penalties for failure to achieve your performance goal. This is different from most, not all of the EPR programs in the state. If you do not meet your collection rate under this program, you are assessed a penalty, page 19, line 8. If you achieve less than the original 50% collection rate performance, you pay a penalty of $1 per tire difference between your collection rate performance goal and the actual number of waste tires collected in the calendar year. So that can be significant. And if you achieve your 50% or greater of the collection rate performance, you pay a penalty of 50 cents per tire between the collection rate performance goal and the actual number of waste tires collected. So this is actually an incentive to increase your collection rate performance goal from year to year. So remember, the initial collection rate minimum has to be 50%, but you get to propose what your collection rate is going to be in your plan. So you probably start off with 50 when you implement the program, but then maybe in year 5, we're gonna go to 70. And at 70, you're gonna have basically no penalty. And so that's the incentive that's built into this program. So manufacturers don't just sit at the 50% collection rate. That's initially in the program.
The incentive is dropping from $1 per underperforming by $1 per hour to underperforming is only 50 cents a tire.
Right, but then if you are performing beyond, if you're meeting your collection rate, then there's not gonna be, if your collection rate's 70 and you're getting 70, there's not gonna be that. So. All right, so the penalties get paid into the Waste Management Assistance Fund to do legacy tire collection. Page 20, line 1, this is the subchapter on reimbursement and cost recovery. This is kind of complicated. You might want me to come back to this again, because basically they have to meet their collection goal in order to send a reimbursement request to another manufacturer or another stewardship organization. And then that stewardship organization can ask for an audit of the request to make sure that the request is valid. And if that audit is correct, then the manufacturer that requested the audit has to pay for the audit. If it's not correct, then the manufacturer that submitted the reimbursement request has to pay for the audit. It is a little wonky.
Yeah, but enough to like not have people abuse the audit.
Yeah,
Right.
it sounds like they really don't like each other. Or don't trust each other.
Yeah, you got it wrong, you gotta pay for it.
So that is basically page 20 and 21, what I just said. And then page 22, if you go through that process and the manufacturer that's subject to reimbursement still doesn't pay, there's a private right of action. There's also a private right of action against the manufacturer. So that's what page 22, line 6 authorizes. And then you can go to skip ahead.
Who would bring the action?
The manufacturer that collects that orphan tire, they would be the one that could bring that action. Then you get to the kind of general provisions that you see in all the EPR programs, the submitted market share data, etc. Trade secret information is not going to be a public record in the state. The antitrust exception from state antitrust law, because you're basically telling people to collude. But they will be exempt from state antitrust, but not when they're gonna collude for price or where to pay, where to sell. The fee is $15,000 annually for each manufacturer or each waste stewardship organization. It's paid into the Environmental Permit Fund. Section 2 is just adding this program to A&R's Enforcement Authority. Section 3 is just adding this program to A&R, to appealing an A&R decision and how that is done. Section 4 is amending the prohibition on the illegal disposal or burning of waste to include on page 30, a person shall not transfer possession of a waste tire to an unlicensed solid waste hauler, so. That's the illegal tire dump issue. And then on page 32. You'll just basically get the effective date. It's on passage, but the key timeline dates are built into the bill. July 1, 2025 is when the waste stewardship organization of the manufacturer needs to register. October 1, 2025 is when they have to submit the plan. January 1, 2026 is the sale ban, and the requirement for implementation of the plan, and March 1, 2027 is the first for the board.
The 15,000, did A&R suggest that, or is that just a based on your experience you started there?
I don't know if A&R suggested that, it came from advocates, so may have talked to A&R, or it's a little dumb, but I don't know A&R's position.
Any questions for Mr. Brady in this building before we move on? I think, with that, we will, sorry. Someone comment.
Just comparing this to other manufacturer responsibilities bills. There was sort of a formula.
Yeah,
Similar, how does this differ?
so that reimbursement process and private right of action, that's only in the battery program right now. All the others don't have that. And this program is unique in that it has a penalty for failure to meet your collection rate. The other programs don't have that built in.
And the fee, like the 50 cents versus $1, I'd say, I don't know of another.
That's the penalty for failure to meet your collection rate. That's, yeah.
Senator Harrison, thanks for coming back. We have a bill to produce to us, it's 265. And actually they're into the disposal of development soils. We have Mr. Vader here to do a formal bill walkthrough, but when you can give us what do you see going on and why you write a bill that tries to address this?
Thank you, Mr. Chair, and thank you, committee. For the record, Wendy Harrison, Senator Window District. And I'm sorry, Mr. Chair, did you say that you had already received the walkthrough or you have not yet? Okay, so if you're going to do it, I'll stay for that. So, the bill concerns development soil. And development soils, that's a new term, invented here in Vermont. It's a specific type of lightly contaminated soils. The specific contaminants are lead, arsenic, and polycyclic aromatic hydrocarbons. And they're found in urban areas, and they're generally from decades of train and automobile exhaust. Their contamination level is higher than the Vermont soil standards, but less than the threshold of hazardous waste. So they're in the middle. You can't treat them like regular soils, but you're not required to treat them like hazardous waste. So the state came up with this middle solution and passed legislation in 2015 to help reduce the cost of construction projects. That was the purpose of the bill. The soil can be kept on site, covered with an impervious surface such as an asphalt parking lot, or disposed of off-site in one of three ways. Two of these ways have never been used, and those are the two that this bill proposes to put under a moratorium. I became aware of development soils this fall when I heard from the town of Vernon that these soils were proposed to be put in an unlined gravel pit. The town had heard from adjacent property owners who were concerned that their drinking water wells could be impacted, reasonably so. I contacted the Department of Environmental Protection, spoke with the staff, and learned about these soils and disposal options. I have experience in landfills as a solid waste director, and I'm familiar with methods of disposal, classification of solid waste, monitoring wells, and typical requirements for disposal sites. In this case, contaminated soil was proposed to be put on top of uncontaminated soils in an unlined pit, which is not good practice in multiple ways. Upon further investigation, I became convinced that this disposal option could cause real environmental harm. The bill would put an immediate moratorium on the issuance of a new certification for a categorical solid waste facility that is permitted to receive development soils. That's one of the two methods of disposal. And the second is disposal of development soils at a receiving site. And you can ask for more details from Ledge Council. But again, neither of these processes have been used since they were created. The moratorium would be in effect until necessary rules are adopted to protect the environment and neighboring properties. These rules would add specific, reasonable, and typical requirements to future permits, such as protecting surface and groundwater from contamination, preventing contamination of drinking water and soil at the site, requiring a control plan for the site, and financial assurance that the site could be remediated or closed. So all of those requirements for the new regulations are in the bill. I can speak in more detail to any of them if you like. I think this is an important thing to do. I have not heard any opposition, but this is when that would occur. But just keep in mind that this option has never been used. And if it had been used in this case, it could have contaminated existing water, potable water supplies. And it's just bad practice to take contaminated soils, however lightly contaminated, from a site and put them at an uncontrolled, unlined site that has less contamination. I obviously support this bill and really hope that you take it seriously and pass it.
Are we in essence then sort of upgrading contaminated soils, to development soils to the status of hazardous waste?
I don't believe we are, and obviously council would need to chime in on this, but the other options are still available. What is typically done with these soils is that they're put on the site or a nearby lightly contaminated site, covered with asphalt or some other impervious material. And then there's also a note put on the deed that they are there so that future owners of the property understand that they're there. But the theory is that they're not going to cause any more of a problem than they already were causing. And it does help development in that it's less expensive than trucking them, and just the cost of disposing of hazardous materials is very expensive.
Any questions for Senator Hill?
What happened in Vernon? The permit was not issued. Thank goodness.
Turner.
How does a soil that's under jurisdiction here, how does it get to be like that?
It is from decades of train exhaust and auto exhaust, and it's mapped, it's on the A&R map. My house actually is in that area, but it's a lot of our urban areas, so it's actually, it's worth you knowing about
It's
this.
sort of ambient air. If it's
Previous
area-
ambient air, like previous air pollution, essentially. And some existing, with automobiles, but automobiles have gotten.
doesn't that spread pretty much everywhere?
Well, I mean,
Actually,
yeah, you'll have to ask other people.
Yeah.
But from what I know is this settled in the soil. Because they've done soil testing and it's there and it's mapped, which is really helpful.
rains out.
It's on the A&R out.
Yeah, I mean, we've got a few spots.
Well, most urban areas have them, and actually I should mention, V-Trans, you should hear from V-Trans because they do have these soils and in theory, they may be someone who would want to use this. The process that this bill proposes to put on moratorium. But so far, my understanding was that. They have been able to find sites that are already under their control to put the soils that they come up upon. But I would suggest that you have them as.
I think when some of this came up in 2015, we worked on it before, Burlington was experiencing problems. They had a Moran generating station right in the heart of downtown, pretty much, right?
Yes, and that came up in conversations too, Burlington, so you may want to speak with them, because this would. Make the options for these soils. Smaller, although you can make an argument that this was intended to. Have the soils put in receiving sites that were at the same level or worse of contamination is my understanding. So there's a legislative or. There's the rules and then there's the implementation of the rules, and my understanding of the rules was that it was not the intention that you put soils. That are however contaminated in a place that is less. Without
So China,
operations,
we can't ship to China like we used to. do.
if you wanna pay for it, probably not responsible and not financially feasible.
Thank you very much.
Thank you.
Right, Mr. Grady, you could walk us through the bill, please.
Well, that was a pretty good summary.
Yes.
Just a little bit more context, the 2015. Issue of the 2015 legislation, as the chair referenced. There were soils in Burlington and the developer was unsure what to do with them. Because they were exceeding the soil action levels, but they weren't technically hazardous waste. And the landfill wasn't sure if they could take them either. So they were just sitting on site trying to find some sort of disposition. And the 2015 law statute, which then directed an amendment to what's called the I rule, is what led to the section of the law that would be in part subject to this moratorium. And so it really was to address an exigent need at the time, but through the rulemaking and the authorization to reuse those soils on site as covered, it took away a lot of those issues, especially since the landfill is now authorized to take soils that are reused on site. But Senator Harrison, the issue that arose in her district does highlight those two other options. And to be specific, right now, in the I rule.
Is the I rule this investigation or remediation of contaminated property?
That is the I rule, yes. But I have to note that the I rule is currently before Elcar for amendment. So the citations, some of the citations in the I rule in 265 may need to change depending on what Elcar approves.
Do you have another date it's coming up? I don't remember seeing.
I think I rule and use of waters are on February 6th.
Okay, makes sense. We just got another pack yesterday, so need to catch up. Okay, thank you. And then rulemaking, what, is this the first time that rule's coming through, or there's already in fact announced?
No, this rule has been on the books for a long time.
Yeah.
They are just proposing changes. Some of those changes relate to the school action levels of PCD testing. But they are making more comprehensive changes as well. But in section 35 805 of the I rule, that is the section related to development soils. And that section allows for the disposal of development soils at categorical solid waste facilities. A solid waste facility for use as alternate daily cover. Or an approved receiving site that meets the requirements of subsection D of the section. So a categorical facility is a facility that's authorized under state statute for inert waste. It's supposed to be for waste that basically will not pose a threat to the environment. And examples of categorical facilities are stump dumps, bridge or highway construction debris, concrete, masonry, mortar, or other categories of inert waste. Senator Harrison already noted this development soils is contaminated. It is defined as being contaminated by lead, arsenic, or PAHs, so polycyclic aromatic hydrocarbon. So it's not inert. In addition, the third option, an approved receiving site that meets the requirements of subsection D. Subsection D just says prior to receiving development soil, a work plan for sampling of the site shall be submitted. And that sample has to provide discrete methodologies and a grid pattern for what is there. That's really it. It has some general requirements for what type of contamination is there already. As Senator Harrison referenced, it has to be R equal to or greater than the concentration of the development soil proposed to be received. But the site that was being proposed in Vernon theoretically did not meet that standard. And that's it. There isn't much else that's required for that receiving site. So that brings you to S-265 as proposed by Senator Harrison. It is a session law moratorium. It would use the same definition of development soil that is in the I rule. That is one of the citations that will likely need to change. That's gonna, I think it's going to be 2012 instead of 13. And the receiving site has the same meaning as in, again, the I rule. And so notwithstanding the authority under the I rule for that categorical certification disposal or that receiving site disposal, the following are prohibited until 30 days after the rules are required. It's that basically you cannot dispose of development soils in a categorical waste facility or at an approved receiving site until the agency adopts on page 2, line 19, rules that establish criteria or requirements for the disposal of development soils at categorical facilities or receiving sites. And those criteria need to protect surface water, you're on page 391, and groundwater from contamination. Page 3, line 3, prevent contamination of drinking water sources in proximity to the disposal site. Page 3, line 5, prevent further contamination of soil at or in proximity to the disposal site. And page 3, line 7, require the owner or operator to implement a control plan for the management of the site, including regular monitoring of groundwater, surface water, and soil. And then last, there has to be financial surety to ensure the viable remediation or closure of the site when necessary. So that's what it would be required in rulemaking, and that would be required to be adopted in order to lift the moratorium on disposal at a categorical facility or receiving site of development soil. But as the chair might remember, well, Elkhart just ran into an issue with a moratorium.
I'm appreciating the new language here.
And what happens when Elkhart objects to a rule that is a trigger for lifting a moratorium? So Anthea and I worked on language to address that. So the moratorium shall sunset 30 days after the effective date of the rules required, provided that LCAR has not objected to some or all of the rules pursuant to their objection authority and has not filed that objection with the Secretary of State. And the moratorium shall not sunset if LCAR objects to some or all of the rules and the agency files those objections. And then on page 4, the moratorium shall not be reinstated if LCAR subsequently objects to the rules at some point in the future. Remember, LCAR can call in any rule at any time. So if they approve the rule and don't object, the moratorium is lifted, but then you subsequently, LCAR calls that rule back
Yeah.
and objects to a part of the rule, that doesn't reinstate the moratorium.
So that, if, for committee members who weren't in there, remember we did the moratorium on hunting peyote with confidence. And 2 years ago. And then when LCAR objected to the
Oh,
rule that provision of the fur bearer rule. The department reasonably enough argued that the language in the bill said they just had to file the rule. So even though we had objected to that portion of the rule, they filed, and they said, we're good to go, and that's how.
Yeah, we
it became,
did.
And we really didn't have a sturdy legal leg to stand on, and like, okay, that's my take, that's a fair way of looking at it.
so this protects us from that. So-
I mean, there are definitely legal arguments that the board should not have gone forward and lifted the moratorium. But the board also has an argument as well.
Yeah.
And that is likely going to be litigated because advocates have already filed.
Yeah, so,
Will similar language then be in all bills that are.
When there's a moratorium, yes.
older advisory,
Well, you answered the question I was about to ask.
You avoid all that with this language.
Yeah, all right.
And be pretty careful.
have you had any discussions with ANR when you were drafting this?
No, I haven't. I mean, I have talked to A&R about the I review. But more about the PCB school action levels. That's honestly an opportunity for them right now. They have an opportunity to address S-265 right now if they wanted to.
By amending the rule.
Right.
In the process.
Yeah.
Yeah, okay.
So you might not have to pass this. You might be able to achieve the intent of this
Right.
in LCAR.
Is Matt Chapman the right person?
Yes.
Yeah. All right. Any further questions for Mr. O'Grady on 365? Senator Harrison, anything else you want to chip in now that you've heard his thought?
No, I appreciate your consideration. Matt Chapman is who I was working with in finding out the process. I appreciate Ledge Council and please let me know if you need anything else from me. I'm sorry, I do have one other question, just until this is passed. Should we be on alert for other applications for this? To use this project?
It's possible that an application can be submitted and approved until this is passed, yes.
Should we, I don't know if it's a term, but should I or should somebody talk to A&R and say, please let me know if you receive any of these applications or put me on
You might
notice?
want to do that, but I'm also gonna reach out to Mr. Chapman
Okay.
and see about the agency's interest in maybe amending the rule that's about to be brought to LCAR. And see if they agree and would just like to amend right now. Right, it may be a really timely bill that you brought forward, this. And
It's just in time for Vernon.
Thank
Thank you.
Thank you.
Thank you very much.
Thank you. Right? So, let's see, right. We're circling back and forth between different bills. Now, let's send a loop back to 274, and relating the sale of flushable water. So, the Senator, White, you walked us through what you were seeing in the real world that motivated you to write the thing. But we haven't walked through the bill itself, so Mr. Brady, set that, be great.
So S-274 on line 12 of page 1, there is an amendment to an existing subchapter in the water pollution control chapter. And so there's currently a chapter that prohibits household cleaning products that have a phosphorus level, or detergents that have a phosphorus level above a certain amount. And this would be added to that chapter, subchapter. The first thing that's being done is defining both what a disposable wipe is and what a flushable wipe is. So that's page 1 through 7. So a disposable wipe, it's a pre-moistened sheet of plastic or cloth designed and marketed for diapering, personal hygiene, or household hard surface cleaning. It's intended to be disposed of when its use is complete. Flushable wipe is a disposable wipe contained in a package labeled flushable, sewer safe, septic safe, or otherwise indicating that the product is appropriate for disposal in a toilet. You will then see on page 3 in line 8, new sections added. It's a simple prohibition. It says no person shall sell, offer for sale, or distribute for sale in the state of flushable wipe. That would be effective on January 1, 2025. If the person did violate that prohibition, they would be subject to a fine of not more than $2,500 for a single violation. And then in the case of a continuing violation, it's an additional offense, and they'll fine not more than $100 a day for each additional offense. A&R has enforcement authority over chapter 47 as a whole. You don't need to change their enforcement authority, they already have it. If there's enforcement or a secretary's decision related to this, A&R already has the appeal right provision. You don't need to change that either. I just want to be clear, enforcement and appeal is already available. It's just because chapter 47 is something that A&R already has those authorities.
Did we, in the last few years, consolidate all their sort of police powers into a, and then they could reference one thing and that's the right.
Instead of in every chapter saying that A&R has enforcement authority or A&R has, you can appeal A&R's decision in the 35 different chapters. You just move everything to one chapter and list what that chapter applies to.
Compared to other things where we prohibit the sale of something. I don't see a provision that says if you already have them in inventory, you are allowed to.
That is what. So it's a good question, but remember the effective date's January 1, 2025. So you effectively say this is enacted and effective July. You basically have a 6-month period. Yeah.
Okay, thank you. Away.
Thank you, Mr. Chair. So there isn't like a federal or industry definition of what is actually flushable.
No, there isn't. And so Hawaii has a very similar bill. And they have a very interesting purpose or finding section, which finds that there is no standard definition of what is flushable and no standard method to assess flushability. Accordingly, the term flushable may be used by a manufacturer to mean that it will clear the toilet bowl. The U.S. Environmental Protection Agency has urged consumers owning flush toilet paper to properly dispose of disinfecting wipes, other items in the trash, not the toilet, stating their failure to break down the sewer or septic systems can damage a home's internal plumbing or local wastewater collection facility. Then I wanna read this next sentence. because-
This is a Hawaiian.
Irish poet, about to speak.
The legislature finds that according to some utilities, the waves can twist into ropey wads. Either in a home sewer pipe or miles down the line, they can heal with grease and other cooking fats. To form massive fatbergs that block pumps and pipes, sending sewage back up.
Yeah.
That is why there is no standard for flushable and why you want to keep wipes out of your wastewater treatment systems, so avoid those massive fatbergs.
I would like to create a finding section in which we
Yeah.
vote that.
Yeah, yeah, now
Putting it on the radar.
there's gonna be a lot of competition to report this bill, I'm gonna want to share that time. There was a London sewer episode.
Yes.
They had one of these things that was like the size of a school bus or something, you know, incredibly disruptive and expensive and apparently really hard to take apart. Is they're ropey,
I do have a serious question.
yeah,
Sorry, thank you. One of the things that we talked about when Senator White walked through this. Earlier was that this is not about banning the product, but really changing the packaging or the label. And I just want to check because the like functional part of this bill is a person shall sell, offer for sale or distribute for sale in the state a flushable wipe. And of course, flushable wipe is defined as something that's in the packaging that says flushable or whatever. I mean, we think that is, I don't want somebody to like read, section 1383A, and be like, we're actually banning the thing.
Yeah.
So. Right, it's not a ban on the sale of a wipe.
Right.
It's the ban on their labeling, and other states have taken a slightly different approach. And instead of a ban on labeling it flushable, it's a mandate to label the product as do not flush or not flushable, etc. But you're gonna need a sale prohibition either way. I didn't really see. Having used diaper wipes multiple times, right? It's like, if it's not limited, if it's labeled as not flushable. I wouldn't have managed it differently. If it was labeled as flushable. You might have said, oh, this is gonna break down, right? And it doesn't break down.
Because this language. Of course, we could pass this and then in the future. Have another bill and change it if somebody, and wonder about what happens if someone does come up. With what is in fact a flushable wipe. That it would biodegrade and would not have chemicals that would contaminate.
Then you have to revisit.
Just revisit it.
Thank you, Chair. That question was asked and I thought the answer was no, but perhaps you have other information. There is no currently biodegradable wipe like that. There's none, but there could be. Okay, there's not one that we would want to have an exemption for or something that actually does.
Right, and remember this definition is it's made out of plastic or cloth. If it's then somehow they make a mushroom one, right? Then that's not, not made out of plastic or cloth.
Why isn't there just made out of paper?
People buy this version, I guess, and.
Yeah, this is,
Yeah.
so the language you're using to describe flushable, you're feeling that that's fairly robust in terms of someone not working their way around it.
Right.
appropriate for disposal and toilet. That seems like a simpler, clearer pathway.
I think you will get support from your wastewater treatment facilities around the state for this.
Yeah, yes.
And I might, Mr. Chair, you were kind enough to look at the Hawaii examples. Are there any folks that you would recommend that we hear testimony from? I have a few, but was there anyone that you worked with that you'd say?
I mean, just the wastewater treatment operators, I mean, they're the ones that deal with this and. As I know, it's been an issue for them for a while. So that's who I'm talking to.
Thank you.
Somewhere someday there will be a statue of you and a wastewater treatment facility.
Okay, I told Dylan that my one
On
thing.
top of the fact for.
No, this is my gift to my husband, and I told him that one day there will be a Dylan Christ wastewater facility treatment plant. If I ever.
Great, what? Yeah, I think we have one more ready to go over with you.
Yeah.
Well, any other questions on this before we move on? Okay, great. Gonna be a lot of competition report this.
I know.
See.
I know.
S 286, an act relating to the regulation of accessory on-farm businesses.
So, you all may recall that a few years ago, you amended Title 24 and Municipal Land Use Authority to exempt from municipal regulation, municipal bylaw regulation, accessory on-farm businesses. And you defined an accessory on-farm business as an activity that is accessory to a farm comprised of one or both of the following: the storage, preparation, processing, and sale of qualifying products, provided that more than 50% of the total annual sales are from qualifying products that are produced on the farm at which the business is located, or its educational, recreational, or social events that feature agricultural practices or qualifying products, or both. Now, the issue has come up that the definition of qualifying products is defined as a product manufactured on one or more farms from commodities wholly grown or raised or on one or more farms. There is a farm that produces beef, produces potatoes, but doesn't produce corn, that wants to start manufacturing shepherd's pie for donation to food insecurity or food security organization. But he cannot do that right now under the accessory on-farm business exemption, because he's getting the corn for the product from elsewhere. So the product is not wholly from the commodities from the farm.
And we have like a principally produced.
Well, that's if you're going to be farming, right? This is if you're going to be an accessory on farm business. And so what the proposal is in the amendment to the municipal exemption is to allow those qualifying products from commodities that are principally produced. And the NRD already defines what principally produced means to mean more than 50%. So the farmer that's producing the shepherd's pie would be able to sell that product and qualify for the accessory on-farm business exemption.
And principally produced, we do this by weight. You know, like if they, how much potato, how much beef, how much corn.
There's a whole definition by volume or weight. Depending, you know, because if it's a liquid.
I remember the blueberry muffin.
Right, and then there was the whistle pig.
Oh,
Right? Because the water he wanted the water from the site to be part of the ingredient of the whiskey
Yeah.
to exempt him therefore from, and the court said, no, water is not.
Won't constitute an ingredient.
But the additional part of this bill is that there is no exemption under Act 250 for accessory on-farm businesses. As the chair already noted, you can principally produce an agricultural product on your farm and be exempt from Act 250. But that requires 51% of the products you be coming from your farm. Now, if a qualifying product is the 51% under the accessory on-farm business, there's a logical need or connection to adding an exemption in Act 250 for that accessory on-farm business as well. I knew you were gonna be fun. Good, because you always in Act 250 exemption, you're always the one.
I didn't say it.
I know. You're all.
It's a deeply felt sigh that comes from
Yeah.
contemplating the
From-
sort of exemption to Act 250. If you want
Understood, I was sighing over the complexity.
But you will see that exemption being added on page 1, section 1 of the bill in the term. What is not development, so what is not subject to Act 250, because Act 250 applies to development. It would not be the construction of improvements for an accessory on-farm business. Located on a tract of land primarily devoted to farming, and that meets the definition of accessory on-farm business. Which now, the qualifying product has to just be principally produced on the farm instead of only from commodities on. So that's what this bill is.
Is there, other than the instance that were you cited, which was are you aware of other applications of this? I mean, for instance, there's a restaurant, a farm/restaurant in Woodstock, right, or close by, that became controversial.
Well, not because of this reason, but. It's the restaurant versus, my understanding was because it was a restaurant, not and they're not trying to sell the pie in. The location, they're trying to manufacture, wholesale it,
Manufacturer, yes.
but that's.
Right, and was that restaurant claiming an exemption under, it's an on-farm accessory business?
Yes, it was.
Yeah.
It was, and this may make a business, it might make it easier for some businesses to qualify. I mean, that is really the intent. The shepherd's pie is the specific reason why Senator Carr offered this at the request of advocates, but you could see other products that could fall under this.
See, so this is manufactured for distribution, so this is like whatever, very attractive word you call it, but. I'm just trying to think a little bit. About what kind of things we might enable that then we might. I could potentially have sort of regrets over, oh, this was a little more business-like and a little less. Accessory, I didn't know it's not. Anyway, I'm not gonna be able to answer the question very well.
I understand the question. I don't know the full universe of what could be proposed. I think maybe you talk to the municipal planners and see if they have a concern with this. They have examples. I do know. At one point, there was a proposal for a beer maker or a soda maker to qualify for this. And they weren't really getting much of their product from the farm. And they wouldn't have qualified. I don't know if you're gonna bring that kind of product in, whether or not you want to. That's a policy decision.
For sure, like the, the restaurant one. the difference between living next, lived on a farm for 20 years. The difference between living next to our farm, which was pretty much pitch black at night. And quiet compared to if our farm would suddenly house a restaurant that had people going, every evening. Outdoor events and lights and parking, would have, for the neighbors, I think they would have felt like they didn't live next to a farm. And
We
I had
had
to go to another,
just very briefly, absent the Act 250 exemption, what would this entrepreneur have to do? They have to get an Act 250.
well, he might have to get an active 50 permit because of. Unless he somehow qualified as farming for the principal production. Of that product. But I don't. It's hard for me to say what. He would have to do, or
They don't need an Act 250 permit to run the operations, it's to build the facility,
construction of improvements, right?
yeah.
Thank you very much for your help this morning. Right, how about we've been here an hour and a half straight, how about we take a 15-minute break and come?
Sound ridiculous.